Good afternoon, everyone. Today we are going to discuss the topic of International Criminal Court, and we will try and evaluate the effectiveness of International Criminal Court um, in prosecuting the war crimes. So this topic will cover learning objective G7 and G8 from our curriculum, and you can find more information in these sources. So basically, the two core sources are Joshua Goldstein and Pevenhouse, Chapter 7 from Pevenhouse, International Law, Organizations and Human Rights, and then Baylis and Owens, the Globalization of World Politics, Chapter 18, International Law. So you have some specialized websites as well where you could find more information on the case studies. So basically, what is International Court, right? On July 17, 1998, after 5 weeks of intense negotiations, 120 nations overwhelmingly voted in favor of the Statute of Rome and established the International Criminal Court to try war crimes, crimes against humanity, and genocide. The ICC was created as a global judicial institution with an international jurisdiction complementing and national legal systems, and can only step in when countries are actually unable or unwilling to try criminals in their own national system. Unlike the International Court of Justice, the International Criminal Court, unlike the World Court or International Court of Justice, in which states can only bring cases against one another, the ICC has the capacity to try individuals as well. And unlike the Rwandan and Yugoslavian war crime tribunals, its jurisdiction will not be chronologically or geographically limited, but and it will not be retroactive. Okay. So, why is ICC important? Basically, ICC helps to deter future war criminals, promotes universal justice. It actually aims to end impunity, help and end conflicts. Is trying to be an alternative to the ad hoc tribunals and complement national judicial systems. So what would be ad hoc tribunals, right? We have two recent cases of ad hoc tribunals, ICTY and ICTR, or International Crime Tribunal for Yugoslavia and International Crime Tribunal for Rwanda. So these two are examples of ad hoc tribunals that serve to punish those found guilty of war crimes, crimes against humanity, rape, and genocide. These tribunals serve to show that a permanent tribunal is needed in that had there been one in place to deter future criminals, perhaps innocent lives will not have been lost. So there are those people who say that ad hoc tribunals also serve no purpose, but they are wrong. Usually those people only look at the negative side of tribunals and not the many lives that are saved because tribunals are brought to justice. Okay. So basically in 1993, following the Resolution 827, United Nations Security Council created an International Criminal Tribunal for Yugoslavia for the prosecution of persons responsible for serious violations of international humanitarian law committed in the territory of former Yugoslavia since 1991. And in 1995, the United Nations adopted the Resolution 955 of November 1994, called International Criminal Tribunal for Rwanda, ICTR, for prosecution of persons responsible for genocide and other serious violations of international humanitarian law committed in the territory of Rwanda between 1st of January 1994 and 31st of December 1994. It may also deal with the prosecution of Rwandan citizens responsible for genocide and other such violations of international law committed in the territory of neighboring states during the same period. Okay, so these two tribunals were actually created only, or let's say, only addressed the cases in Yugoslavia and Rwanda. They were not international institutions or international organizations that could put under trial other leaders responsible for war crimes. Therefore, we can have several problems of the ad hoc tribunals. First and foremost, we could notice that there is a selective justice because, for example, not all of the conflicts or let's say post-conflict situations were subject of the war crimes tribunals. Then another problem is slow pace of arrest and prosecutions, whereby not all the time all the people who were involved, leaders and other individuals who were involved in the war crimes, are actually prosecuted on spot, and that actually can take longer time. It is very difficult to manage and the tribunal process for the simple reason that this is very expensive, and then there might be not enough experience in those parties that are putting under trial the people, and then not all the time it is possible to arrest the suspects, because they might actually flee the conflict zone before they were subject of the arrest. Okay, so I'm going to introduce in brief what International Criminal Court is and what is the difference between the International Criminal Court and the International Court of Justice. So International Criminal Court is located in Hague, Netherlands. The main purpose of International Criminal Court is to try the individuals for genocide, crimes against humanity, and war crimes. International Criminal Court is an historical moment in which the humanity or international community is trying to prevent atrocities and such as of international crimes in certain local conflicts that occurred after the 1990s. And International Criminal Court was established in 1997 as a result of 120 countries signing up the Rome Statute. It actually started to work in 2002 after the ratification of the Rome Statute by 60 states. Now, a little bit about the structure of International Criminal Court. There are judges, or 30 judges. That is a must for them to have an established experience in criminal or international law, including humanitarian and human rights law. They will act as impartially and will be neutral, which means that even though a certain judge will come from a specific country, they're not going to actually support the country they're coming from, but they are going to primarily they're going to support the values, and they're going to support the agenda of the International Criminal Court. And the prosecutor is responsible to conduct the investigations and prosecutions before the court. It also acts independently, and it acts as a separate organ of the court. Now, why do we need a universal jurisdiction, or why do we need international court to be acknowledged as an international organization that would try for war crimes? So there's a couple of problems when it comes to the jurisdiction of the International Criminal Court. So even though there are 120 states that accepted the Rome Statute, many states are still outside the system and have a reduced tools to try for serious crimes which occur in the region. So for example, ICC has a very low representativeness in Middle East and North African regions. Some states with large populations such as Russia, China, and India remain outside the system. US is also not part of the International Criminal Court, and one of the specific of International Criminal Court is the principle of complementarity, which means that the ICC is able to act only if the national courts are actually unable to keep their responsibility and prosecute the war crimes at home. So that creates a problem, and we're going to speak about it a bit later. That creates a huge problem whether on how exactly the courts, or let's say about the effectiveness of the court itself. ICC member states are able to pull back the case from the ICC if they feel that they can solve it at home, which is another reason why International Criminal Court was not as effective as it must be. So what makes actually International Criminal Court different is the idea of universal jurisdiction, that the court has an ability to prosecute individuals in a nation. It is a little bit sophisticated to understand the effectiveness of this organization. However, one major difference between International Criminal Court and the World Court is that for the World Court, only the states have the right to complain about each other and to put each other under the trial, whereby in ICC the individuals can be prosecuted for their roles in violations of human rights. So there are three mechanisms that can trigger an ICC trial. A state itself can trigger an individual for trial if the state agrees so. Sometimes, even if the state does not really agree to put a certain individual on the trial, a special prosecutor at the ICC can begin a trial, and the crimes occur in the territory of the signatory of the ICC. United Nations Security Council can also begin proceedings and refer cases to the International Criminal Court. Now, what are the types of crimes reviewed by International Criminal Court? We mentioned them at the beginning of this slide, but we are going to try and explain them a little bit in more details. So first and foremost is the genocide, which is defined in Article 8 of Rome Statute as acts committed to destroy an intent or in whole or in part of a national, ethnic, racial and religious group, such as killing member of the group, causing serious body injuries or mental harm to the members of the group, imposing efforts to prevent births in the group. The crime of genocide involves two subject elements. The general subjective element must cover a genocidal act in Article 6 of the Rome Statute, and mens rea, in which a specific intent to destroy the group involved or a part. So basically, if a certain group or individual was trying to intentionally to destroy another group, that is also called genocide. Now, for those who are going to write their essays on module G, sorry, you will have to discuss the topic. You'll have to discuss the topic of genocide. This is why you could also refer to the International Criminal Court as part of the as one of the organizations which discusses the idea of genocide. Crimes against humanity are defined in Article 7 of Rome Statute and include an attack directed against civilians and exclude military targets. It is a widespread and systematic and does not happen only in small areas, but involves a bigger areas and have a constant character. So most of the time, the activities by the terrorist groups might be classified as crimes against humanity, but because the terrorist groups are actually non-state actors and they do not really apply towards any of the laws of war, are not subject of the laws of war, it would be very difficult to put them under trial. Another type of crime reviewed by International Criminal Court are the war crimes, and this or let's say the articles in the Rome Statute which discuss the war crimes are Article 7 and 8, and the types of war crimes that could be put under trial are the murder, mutilation, taking hostages, intentionally conducting attacks against civilians, rape, sexual abuse, forced pregnancy, using children to fight in armies. All these are war crimes. You can find more information about war crimes in Joshua Goldstein at page 270-273. It is uploaded on your MS Teams. For those specifically who are struggling with working with the IR information, I would advise you to refer to that particular group. And last but not the least, crime of aggression would include the planning and preparation and execution of an act using armed forces by a state against sovereignty, territorial integrity, or political independence of other state. These crimes applies only for political and military leaders and not to the combatants or soldiers. So as you have seen, as a summary of the crimes reviewed by International Criminal Court, most of them are actually or let's say the subjects for this type of crimes are actually on the level of a state. So again, if we would refer back to the terrorism as a phenomenon of 21st century, we can actually understand that it would be very difficult for the states to include any or let's say to discuss any of or to try and to put under trial any of the leaders of the current terrorist groups if ever this particular situation would be sorted. Now, in order for an efficient functionality of the International Criminal Court, of course, the states who ratified or who signed the Rome Statute have to actually offer the full support and cooperation. The problem here is that actually the Rome Statute is an opt-in treaty, which means that the state should choose to accept the jurisdiction and agree and enforce the law, cooperate with decisions, and prove it with political support. The court does not have an independent power to arrest and depends on the willingness of the state to arrest and transfer the wanted person, which means, for example, that if a certain state, even if it had a conflict on its territory, right, and certain leaders or previous leaders are subject to trials, even though the International Criminal Court would intervene, the state has to be the one who would initiate the trial process. International Criminal Court is the first court which gives the victims the right to participate in trials, and it is the first court which actually allow them, the victims, to claim reparations. So if we return back to our topic of just war theory, you can actually see that International Criminal Court is a tool which aims to work with the jus post bellum concept, and or how to or it deals with subjects of reparation, deals with subjects of finding the justice for those who were affected by the war crimes, and so on. One important thing which you guys have to understand is that International Criminal Court is not part of the United Nations system, and it's independent from United Nations. However, United Nations played an important role in its creation, and it provides logistic support. And on the other hand, United Nations Security Council is able to refer individuals for trial, which kind of shrinks from the autonomy of International Criminal Court, and this is why International Criminal Court in a lot of cases is actually blamed for being just a manipulative tool of the United Nations Security Council, or of those powerful states that are part of the United Nations Security. One important point which you have to understand about the International Criminal Court is that you don't have to confuse it at all with the International Court of Justice. Even though they might seem similar, they're actually quite different in their goals and objectives. So International Court of Justice was created in 1946, whereby the International Court of Criminal Court was created in 2002, started work in 2002. Reported to the relation with United Nations, the International Court of Justice is an official court of United Nations, referred as a World Court, whereby the International Court of Justice is an independent way to receive a case. It might receive cases from United Nations, but in the same time it actually can initiate cases without United Nations approval, whereby the International Court of Justice does not have this advantage, and it only works on the interstate level. Both organizations are located in Netherlands, Hague. Both of them use English and French as a work language. However, when it comes to the jurisdiction, as I mentioned before, International Court of Justice deals with United Nations member states and national governments, and will work with territorial disputes, economic disputes, and so on and so forth, whereby the International Court, the Criminal Court, deals with individuals mostly, and the main target is to put on trial for war crimes. Alright, so now we are going to discuss the effectiveness of International Criminal Court. There are various opinions about International Criminal Court. Most of them are not very positive, and some points where the International Criminal Court is actually criticized is the low conviction rate, problem of the state sovereignty. Powerful states are not subject of persecution, and ICC only works for weak states and mostly put under trial. And we are going to discuss them one by one. One idea which supports that the states are not subject for prosecution is the fact that US, for example, is not part of the International Criminal Court. And here are some arguments which I would advise you to use in your essays if you have to write about them further. So the US has refused to ratify the ICC agreement and shows little interest to do so. Moreover, US has pressured many ICC members to sign immunity agreements called bilateral immunity agreements in aim to protect the American soldiers serving in those countries from prosecution. So this is why, let's say, if there were any soldiers involved in peacekeeping missions, for example, in Rwanda, none of them actually were put under trial, even if they committed war crimes. In 2005, after some ICC members refused to sign the bilateral immunity agreements, the American Congress voted to cut foreign aid for those states and basically impose sanctions. So US leaders are actually using their own the power of US and the advantage that US is an hegemonic country in order to achieve their own national interest in it. So again, let's return to the points that I mentioned before. Right, so for the entire 15 years of its capacity, ICC put under trial and convicted only 2 people, and one of them was actually later acquitted. So we do not have to take the low conviction rate as a fully negative variable, because ICC needs to be seen as an independent organization, and it's quite a young organization, so it would take a longer time to be accepted by the international community and to be trusted. Okay. In terms of problems of state sovereignty, you compared to United Nations, International Criminal Court does not have its own police and only relies on state cooperation, which basically means that if the state is not willing to cooperate and even though there were crimes against humanity or or genocide or any other type of crimes that were committed during a conflict in that particular area, International Criminal Court that cannot do much, because they are not actually able to catch the criminals and to bring them in for trial. Some believe that international law in general is quite weak, right? So the international community has to actually work to increase the efficiency of it, and there should be a pressure imposed on the powerful states like Russia, US, China to ratify the Rome Statute and to release some of their sovereignty to give more power to ICC, because most of the states were actually involved in international conflicts, and involuntarily they actually committed war crimes during this conflict. Therefore, it's very weird that this particular states, as part of United Nations Security Council, actually have the right to participate in meetings related to International Criminal Court, refer cases to International Criminal Court, and so on. Some believe, and this was the reason of why a lot of states left the, or let's say, decided to leave the Rome Statute, or let's say decided to leave the International Criminal Court. and the membership with International Criminal Court, then most of them say that ICC only works for the weak states. Okay, so there are some arguments about it. Most of the cases are actually related to Africa, and this is despite the fact that a lot of crimes are occurring everywhere else in the world, including the Middle East and America and Mexico and so on. This sends a message to smaller states that since they are weak, the ICC will touch only them, and that actually gives them an argument to not cooperate with the International Criminal Court. This is why there is a need of an universal there is a need for an universal jurisdiction for International Criminal Court in order to be efficient. So I tried to summarize a small example. So for example, the war crimes in Darfur, in which UN blamed it for genocide, have been referred to ICC after US dropped its objections in 2005. The Darfur case is a difficult challenge for the ICC. Therefore, in 2009, the ICC indicted the sitting Sudanese President Omar al-Bashir, but however, he left the country and flee and left to Chad, and Chad refused to arrest him and blamed ICC for bias. Therefore, ICC faces a difficult balance in holding officials in Sudan accountable for what they did in Darfur. So now that you listen to this information about the International Criminal Court, you're asked to complete the worksheet attached to this lesson as long as you go with the current information. Then you have to read the case study 19.2 on page 311, Globalization of World Politics, and answer the following questions. The ICC is a work in progress, and its jurisdiction is unprecedented, by far from universal. Do these limitations undermine the value of such institution? And here you're going to basically try and give arguments about the universal jurisdiction of the International Criminal Court. And the second question would ask you to discuss whether the attempts to resolve national international conflicts should take into consideration first and foremost war against war crimes, crime against humanity, or any other violations of human rights. So basically these are two reflection questions. These questions are going to actually help you to understand better the topic, and these questions are actually going to be to give you some hints about some analytical and evaluative points you might put in your essays for your exams.